Hello, 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 and welcome to another edition of The Sit Down on the College Football Mafia Network. I'm your host, Nathan Bomber Brown, and with me are two guys I've been trying to get in the same room with me for weeks now, and I'm really grateful that they've been able to share some time with us tonight. We got two legal experts with us. First of all, we have Professor Sam Ehrlich from the University of Boise, right? Boise State.
Boise State, that's right.
And then Philip Sheng. And I didn't ask you your school. I apologize, Philip.
BYU Law School, Stanford undergrad.
That's all that matters right there. That's all you got to say. That's the big two. I want to welcome everybody here tonight. So we're going to get into this discussion. We're going to be talking about the house settlement, and right now the things that's right under the thumb of every parent that has a college athlete out in there, and that is roster limits. I'm hoping that we have a real good conversation. But it was really important to both these guys to really get your comments, really get your questions. So get real active in the comment section. Moen's watching. He's going to flag comments for me, so I don't even have to do that tonight. I feel special. And I really want to make sure that you guys know you're not here for us. We're here for you. And we're going to try to keep it right around an hour. But as long as you guys don't scare these guys off, I think I might be able to get them to come back in the future. So first of all, I'm going to give you guys a chance to introduce yourself. So Professor Sam, why don't you go ahead and kick us off?
Absolutely. My pleasure. And thank you so much for having me. Love the chance to do this and to talk about these issues. And, it's kind of a really interesting timing with really the deadline tomorrow for the NCAA and the plaintiff's response to Judge Wilkins' order, which I'm sure we'll kind of get into. But like you said, my name is Sam Ehrlich. I'm an assistant professor of legal studies at Boise State University. Phil mentioned his alma mater, so I guess I'll mention mine as well. Undergrad at UMass, my law school at Thomas Jefferson School of Law, and PhD at Florida State. So very, very varying degrees of football competence among that. But a huge college sports fan, have really been interested in kind of the legal aspects of, and have studied the legal aspects of college sports for, I'd say almost a decade now. We're getting real close to that, if not longer than that. And it's been an interesting journey from O'Bannon to Alston to now the House case and all the different eligibility cases, the dozen or so eligibility cases that are going on. And it's been kind of a privilege to be able to track them all.
10 years. I love that. That is fantastic. It shows people that you didn't just dive in yesterday trying to get your name up in lights, right? There have been some people that have done that on Twitter, just so we all know.
That's for sure.
Philip, go ahead.
Yeah, so I'm a partner at a law firm called Venable LLP. We're a national law firm. We've got about 800 lawyers nationwide. I do primarily intellectual property law, and that includes, name, image, and likeness. I've been advising in that space for a while. Recently, we decided to form a sports law group. And so, with a group of us, so I'm a former athlete. I played D1 tennis at Stanford University and played professionally a little bit. I was a graduate assistant tennis coach at BYU when I was in law school. And so a group of folks with sports backgrounds decided to launch something like this just in view of all the, the litigation going on in the sports world and in the collegiate space. So super excited to be here. I humbly believe that I've studied this issue of roster limits more than anybody out there. It's become a passion and really just an obsession of mine. And so appreciate you having me, Nathan.
Absolutely. I apologize having to reschedule from last week. Everybody knows I was sick, but it turns out maybe our timing is even better because let's just jump right into the timing. Tomorrow, I believe the 7th of May, the A4 and the NCAA have been charged to come back with some sort of a revisit or a reissue of this idea of these roster limits that really sort of came out of nowhere. They were initiated by the A4 and the NCAA. They were not bidden to do those things. It was basically something that they tried to turn on all on their own. And they just said, wait a second. Judge Wilkins is like, what does this really mean? And now we've seen through all thousands of objections from all these athletes that play all these sports, really, why is that such a big deal, Philip? You say you've been in front of this thing for a long time. I've only been tracking this for about 2 years. What really stands out to you about that?
Yeah, first, let me just point out. So, yes, I think tomorrow we will see something. It's not technically required. So if you look at her order, Judge Wilkins' order from April 23rd, it really says you guys have 14 days to consult with the mediator. So there is a world in which tomorrow the parties come back and say, we need some more time. But it looks like, just from what the what's leaking in the media, it looks like at least the NCAA and the plaintiffs have something that's very close to being ready to be presented. But to your question, golly, this has been just an absolute roller coaster. I started really, getting interested in the roster limits thing when they first introduced the concept about a year ago. I have a daughter, a senior. I have two high schoolers who will be affected by roster limits. I have a senior in high school. Unfortunately, it was told about a week ago she's on the losing side of the roster limits issue. But it's just been this back and forth, like heavyweight, like it's like Ollie Frazier, the third one. It's like nobody gave roster limits, like I'll call them like the group of walk-ons, and I acknowledge it's not just walk-ons, it's scholarship and partial scholarship. We had this bucket of athletes that nobody gave them a chance. And the media didn't give them a chance. Everyone was saying this is going to be approved, no big deal. And then suddenly you have these letters coming in, and then you have the fairness hearing, and then you have the NCAA comes back and says, no, we're not going to do it. Anyways, so we're like in like the 14th round, and Ollie Frazier, you guys remember the Frazier's corner, doesn't let him go back in. But I feel like here, right, the NCAA lawyers are and the schools lawyers are like, get back in there. Let's try to, for a knockout in the 15th, I guess. But it's been crazy. It's been wild.
Sam?
Yeah, I think Phil hit the nail on the head. I mean, the roster limits were kind of a weird, kind of an interesting addition to this settlement. Like the House v. NCAA, it's a case about NIL. It's exclusively about NIL. It's really kind of a two-part case where half of it is talking about kind of past damages for pre-2021, before NIL started, for athletes who were not able to profit off their damage and likeness. And the other side of it being kind of more future-looking is the idea that, kind of this antitrust argument that the NCAA has capped the ability for athletes to be able to negotiate with their schools for revenue sharing, a part of the broadcast revenue, where the broadcasts are arguably, according to this case, using their NIL, and they're saying they should be compensated for this NIL. So the fact that roster limits are part of this from the beginning, it was kind of a curious thing. They weren't added until an amended complaint being kind of the pleading document, the basis for a lawsuit, an amended complaint that was filed alongside the settlement agreement. So it was clearly something that was very much thrown in at the last minute, and kind of I wouldn't say unexpected, since it was kind of reported for, the settlement agreement came out in August. It had been reported since, I think, like April of 2024 that they were going to be part of it. But it was something that I don't think people really kind of understood the impact of them and how tightly drawn they were going to be. And I think a big part of it, the NCAA's just abject refusal to do any sort of grandfathering or phasing in, which would require so many athletes to be cut. And kind of this weird thing where the settlement wasn't, the absolute earliest the settlement could have been approved was April 7th, which was the final fairness hearing. It clearly wasn't. But schools had to make plans. Schools had to kind of act in accordance with the Settlement Act to prepare for the settlement, since they were being told, and with good reason. And I think it's very reasonable for them to kind of think along these lines. We need to start acting to get under the roster limits. And a lot of schools are saying, let's give our athletes a chance to transfer out, to find new schools before this huge glut hits the transfer portal. So that's why you've seen all these different athletes who have filed letters saying, I've already been cut. And that's something that Judge Wilkin was very displeased by, both at the fairness hearing to a lesser extent, and then after the NCAA came back and said, well, we can't do grandfathering because it would cause some serious disruption. Well, Judge Wilkin hit the nail on the head and said, hey, I didn't give you approval to start the settlement. I didn't give you approval to start kind of acting on this. So the fact that you're acting on it, the fact that this disruption of kind of rolling everything back, that's kind of on you. So I think right now, and I think what we're going to see tomorrow is the NCAA trying to figure that out.
Let's not give like the schools and the coaches that much credit in terms of like cutting kids so that they could hit the portal, right? I mean, that's like maybe like a small percentage, small percentage of coaches, really having an interest in their players, saying, look, I love you, but the best thing for you is to go and get in the portal and market yourself. I think that's probably a small percentage of kids. I think the majority of it is, hey, how can we save some money? How do we cut the fat from our teams? Just want to get that out there. You mentioned the disruption part, Sam, and it's interesting, right? And it'll be interesting to hear. You've seen the leaks, right? That they're going to go in there tomorrow and argue that propose a plan that allows sort of voluntary grandfathering. And what strikes me is just sort of the back and forth sort of flip-flopping that the NCAAs and A4 schools have done, right? So they started out, you had in March, they had to respond to all the, hundreds of letters that came. There were hundreds. There were probably around 350 athletes who objected, many declarations from parents and students. I know, I read them all. And so like all you parents out there, very heartfelt letters, athletes who put their names out there. Just incredible, 300 something objectors, right? And the NCAA came back and if you guys go, you guys will remember like all the reports, like the NCAA lawyers like on record saying, oh, like only 9 people were cut, right?
Right.
Hearing, 9 people were cut, right? So they started out, the NCAA started out, telling Judge Wilkin, look, so few athletes are going to be affected by this, and that's you got to grant approval because so few people came forward, and it's outweighed by the 300-something thousand other people who filed claims, right? Judge Wilkin didn't buy that, right? At the hearing, she nudged them in the right direction, said, hey, I want you to grandfather them. It's not that many people. You've told me it's not that many people. And then they come back 2 weeks later and file a brief and say, oh, it's too disruptive. There's too many athletes who have been made decisions on this, right? And schools have done budgeting and finances, and they fired administrative staff, and it's too disruptive, Judge. We can't do it. Judge didn't buy that at all, right? She and then April 23rd she comes out and says, hey, that's your own problem, and you fix it, right? I mean, I think any reasonable reading of that order says you fix the problem. And then so now they're back now to saying like, okay, like we just spent an entire brief telling you how disruptive it was and how hard it's going to be for us to put the toothpaste back in the tube. Right. It's too hard. We spent an entire brief telling you how hard it's going to be. And now they're going to have to try to convince Judge Wilkin that, okay, like, yeah, just make it voluntary. Trust us, Judge. The schools, they're gonna put it back in the tube. Trust me, right? There's no way. And so I'm trying to view it in the lens of like how Judge Wilkin will see it. I'm staying really positive. I just don't think Judge Wilkin will be very pleased with it. That's my own view. We'll see what they say tomorrow. But
so, Sam, as all other people that aren't lawyers, right, that aren't legal historians, that can look at a case like this and see Alston, you see everything having to do with House, and then everything else that was wrapped up into all these lawsuits. Is it common to play chicken with a federal judge?
It is for the NCAA. They've done a lot of this, not necessarily with a federal judge, but they've certainly have kind of an interesting legal strategy throughout kind of their history. Like I've been telling people all along, like this period that we're in right now, kind of in between the final approval hearing and the whatever Judge Wilkin's decision is going to be, depending on what happens. It reminds me a lot of, there was a 10-day period in between June 21st, 2021 and July 1st, 2021. And for those, who are wondering kind of what those dates represent, June 21st, 2021 was the day that the NCAA or the Supreme Court decided NCAA v. Alston, and they ruled 9-0 against the NCAA, and they most importantly, while Alston was the mandate, the specific decision that the Supreme Court made was fairly narrow, they did make really clear in that decision that the NCAA is not entitled to antitrust protection. July 1st, 10 days later, was the start date of various states' NIL laws that would force the schools in those states to allow their athletes to profit off name, image, and likeness. And for those who maybe don't remember, back in 2021, it was kind of an interesting period, kind of early 2021. The NCAA had a plan for NIL. They had a plan with a lot of guardrails and a lot of enforcement mechanisms that really, I think, a lot of people are kind of crying out for right now. Kind of restrictions on athletes' abilities to enter into vice industry deals like gambling or alcohol or tobacco or that kind of thing. Preventing athletes from entering deals with kind of particular industries that have been seen as kind of like less than reputable in terms of NCAA amateurs in the past. Like we were fresh off of the whole scandal with Adidas where they were paying athletes to go to particular schools. How quaint that scandal is these days.
Right.
But also that would have prohibited pay for play, would have really restricted NIL, would have required reporting of all NIL deals. The problem is in 2021, in January of 2021, the Department of Justice filed a letter with the NCAA, or filed a letter to the NCAA and said, hey, if you go through this plan, it's going to violate antitrust law. And the NCAA said, well, we have this Alston case coming up in front of the Supreme Court. We're probably going to win this case. We feel like we're going to win this case. We're confident we're going to win this case. So we're just going to bank on that. And of course, they lost 9-0. So it didn't quite work out for them. But what was clear in those 10 days after June 21st, 2021, when the Alston decision came out, is that the NCAA had absolutely no plan for NIL. They had no plan aside from the one that the Department of Justice had said would have violated antitrust law. They had nothing else aside from that. So they had to scramble, and they had to impose an interim policy that is still in place to this day that really doesn't solve much of anything, and they just don't have the enforcement mechanism to be able to do anything about it because they only had 10 days to react because they just didn't plan ahead. They didn't think about it, and they didn't think that these judges, these federal judges, would rule against them, and we're kind of in the same situation right now.
Philip, you want to add anything?
Yeah, I mean, I think your original question was, does it surprise you that the NCAA is playing chicken with the federal judge?
Yeah.
Or was it like, it surprised you if anybody?
Because as a layman, it seems crazy. It seems crazy.
Nobody should play chicken ever with a federal judge, right?
Right.
It's just, like I don't necessarily blame them the first time, right? So at the April 7th hearing, Judge Wilkins suggested it. All right. In fairness, she I think she even said, maybe there's something we can do to help. Maybe there's something that we could, do for these kids, right? She never said like, hey, legally, I think you're required to do it. And I think that's where the NCAA and the Power Four schools, they took that as a sign that maybe she wasn't really being serious, right? So that was like the first game of chicken, right? Then you get this order. Like, look, I posted on X the other day, and you folks go check it out. Like, I posted the court order that came down on April 23rd, and I highlighted, I sort of underlined language from it. Like, I don't see. Look, I think I'm a pretty good lawyer. Look, I've been practicing for 12 years. I clerked for a judge. I feel like I'm a pretty good lawyer. I'm reading this order, and I just don't see how it's possible to interpret that as requiring voluntary grandfather. I just don't see it. I'm going to be very curious tomorrow to see what the lawyers argue. And let's be clear, these are some of the most well-known lawyers in the country. These are the folks that you go to for bet the company. Like when you're in a ton of trouble and you need to get out of whatever it is you're in, these are the folks you call. They're charging you $2,000 an hour. And the boss comes to you and says, fix it. The response isn't like, oh, no, we don't fix it. We're gonna, when the directive to you as a lawyer is, I don't give a crap what the judge told you. Like, you find a way to fix it. And I feel like that's where we are at this point. Like I don't like to put absolutes on things because I thought there was no way in heck that they were gonna take a run at this. I think I posted on Twitter that if they met, there's zero chance. I was wrong. It looks like they're gonna actually try to do it tomorrow. But I just feel like this is like, down by 8 in the fourth, like 10 seconds in the fourth, we've got to score a touchdown and convert on the 2-pointer. I mean,
Right.
that's where the NCAA is right now. But it did surprise me that they were playing chicken the second time, because there's a real world in which Judge Wilkin doesn't even entertain. She just auto denies, right? It gets filed, and within 24 hours you get the auto reject, and she doesn't even entertain what she had to say. It's a possibility, but I'll know more when I see it tomorrow.
We got, I'm sorry, wrong one. We got a comment here from Kathy. She's asking, is it a written order tomorrow, or is there an actual hearing? Do you guys know if there's a hearing and if it's streamed?
Yeah, there isn't a hearing. There won't be a hearing. It's just gonna Judge Wilkin just asking for a brief to be filed, kind of just outlining what they're planning on doing.
Okay, and I thought that was the case. Go ahead, Phil.
Yeah, I'll add. So tomorrow you'll get a joint brief from the two sides, and then I'm reasonably certain you've got the objectors. So Judge Wilkin.
Yeah, I was gonna say.
Just like the dynamics of this case is so weird, right? So it's like you have the two sides, right? When I say the two sides, I'm not referring to like the plaintiff and the defendant. Like those two sides on the opposite sides of the V, right? Versus in the case, like they've come together. They're like in the same bed right now. And so when I say the two sides, I really mean like the NCAA, schools, and the plaintiff's lawyers, right? The lawyers are supposed to represent all the kids. Like they're like in this group, and then you have the objectors. So the parties, defendants and plaintiffs, will file something tomorrow, explaining what their plan is, and then I'm certain the objectors, they are going to put in some really good briefs. You have some very smart lawyers on that side. So folks who are worried that they're not going to have a voice, I'm certain they will let Judge Wilkin know what the NCAA and schools and the plaintiffs' lawyers especially, right, what they're up to.
Okay. Yeah, this is kind of an interesting dynamic. I don't think you see this very often with these class action settlements. I don't think you see it at all, really, kind of in all of law. Like, not only the fact that the plaintiffs and the defendants are kind of on the same side of this issue, that's not really surprising, because they're both trying to get the settlement passed. They both agreed to the settlement. They both came together on the settlement. They both have a very strong interest in getting the settlement passed. Neither of them, I think it's clear that neither of them particularly want to go to trial at risk, and risk losing at trial. And if they don't lose, having whatever judgment go to the Ninth Circuit and then possibly the Supreme Court after that. But the objector part of this is really an interesting dynamic. And the fact that Judge Wilkin in particular has highlighted a few of these objectors and said, you need to make sure, plaintiff and defendant, you're going to make sure that these objectors' attorneys are in the room with you. And I imagine, and I have to throw in my buddy Joe Sabin, a professor at Southeast Louisiana. He called these objectors that are going to be in the room babysitters, which I think is just a perfect metaphor for what kind of their role is and what Judge Wilkin has kind of tasked them with. But I think more than anything, Judge Wilkin is going to be looking for whatever is going to be really interested in what the objectors, what those particular attorneys have to say coming out of the room. Is whatever deal is being proposed something that they agree with, something that they strenuously object to and say, this is not at all what's kind of in your order.
Right.
And I think that part of it is like, I'm almost more interested to see what Laura Rutherford and Mo Lampkin and what they have to say about this, even more than the plaintiff and the defendant.
Isn't that a bit of an indictment, though? That stood out to me, the fact that it seems like these two parties got together, meaning the people that want to give NIL funds to players and the schools administrators that want some sort of organization around it. They almost did it with the lights off, without anybody really having their phones on, and just everything was done in darkness and away from all of who you're now calling objectors. These are the parents or even the players that are going to be cut down and going to be impacted with entire sports leaving their schools. I think that's more of an indictment than it is anything else. So yeah, it might be that they want to get the judge to go through with this, but I think this is a whole side of the case that never even was talked about before, and it seems kind of like garbage, practically, that they tried to sneak this in without having any sort of oversight or input.
It's just such a weird part of the settlement because it's something where throughout so many different briefs and so many different documents that they filed and countless pages of everything, they've explained very thoroughly why the salary cap is important, why the third-party NIL restrictions are important. They've never really explained why roster limits are a thing.
Yeah, I've never seen anything.
I have a pretty strong suspicion about it. The whole reason why roster limits are here in the first place is just to save the schools money. And yes, that's a valid concern. Schools are going to have to now pay their athletes, and it's honestly paying these athletes, paying especially the football and basketball players who have done so much in terms of their labor for generating revenue for the schools. It's very important, very deserved, and very needed. The issue is, if you're doing it by instituting these roster limits so immediately and having these athletes be cut, that's what really kind of strikes me as really strange. And yes, it is kind of to save some money, but I think the NCAA, I don't know if they're forgetting. I think, in fact, they're trying to hide it. There have been a lot of cases, a lot of similar antitrust cases where they've been sued over certain things. Law of the NCAA, a case back in 1998, where they tried to institute a rule saying that certain basketball coaches at the end of the bench, after your main head basketball coach and two assistants, you could have a CEC coach, a controlled compensation coach. You can only make a certain amount of money. They were sued. The NCAA were sued and said, and they came back with, hey, one of the reasons we need to do this, one of our pro-competitive justifications for having this rule is we need to save money. And the court said that is absolutely not a justification. That defeats the purpose of antitrust law, which is to promote competition and to ensure and really drive up the cost of labor in a lot of different ways when you're talking about labor markets.
Philip?
I forgot what the question was, to be honest with you.
That's okay. I didn't mean to catch you short. I apologize.
No, it's fine.
Basically, I just think that it's remarkable that this is continuing, and it now seems like we've lost a thread. Where we originally started is not where we really should have ended.
Sam mentioned earlier, right, that the roster limits was put into the complaint, the second amended complaint. It was in September of 2024. It was put into this amended complaint, and lo and behold, at the very same time, they filed this settlement agreement that settles that claim that they made, right? So the plaintiffs amend their complaint and said, hey, NCAA, hey, here's this new allegation we found, roster limits violates antitrust law. And then like an hour later, you see the settlement agreement hit the docket, and lo and behold, they're settling the roster limits as part of the agreement, right? There's no doubt in my mind that the parties came together as part of the settlement agreement. NCAA said, hey, we want this. School said, we want this. Hey, will you put that in the complaint for us so we can settle it? Like that's how it went. I mean, that's the only reasonable way to interpret that. And it's morphed into this thing. And I don't think the NCAA and schools ever thought, right, that we'd be here today. And that's what's the greatest part of this story is like, I've got to give a shout out to there's a group of parents out there. If you've been following this issue, you know them well. It's the No Roster Limits account, and they're on X and they're on different social media, right? I mean, like, it's a group of parents. I've come to know them very well. They're parents just like everyday people. Like one's a marketing executive, one's like a school administrator, just like normal people, right? And they banded together. They took on like Kessler and Berman, the NCAA. They're the juggernauts of the legal profession and the machine that's the NCAA's PR, the PR machine, right? They took them on, and like you started seeing letters come in, right? John Weidenbach's letter, that was cool. Then you get Keaton Rice's letter, the Auburn Storm, that was kind of cool. And then it just slowly starts snowballing, and then you start seeing advertisements on X for this No Roster Limits account. They're setting up Zoom meetings. I joined those Zooms. The first one had like 50 people. The next one had like 200 something people. And then you start getting hundreds of people objecting. And I'm just picturing like the NCAA schools, like, what the heck is going, like, who are these people? And why did they get in the way? I don't think anyone thought that we'd be here today, us three, talking about how Judge Wilkin has thus far denied the settlement twice now, right? I mean, the objectors have won twice. They are winning. And so like, I got a lot of messages, today, the last few days, like parents freaking out. Admittedly, I was, worried. I was concerned hearing all these rumors and stuff. But at the end of the day, like the objectors are winning. Like I mentioned, like down 8 points. This is like like Reggie Miller, 8 points in 16 seconds, right? I don't know. I was when that happened.
The Knicks,
right? Like,
playing the Knicks in the Garden.
No, that's like where we are right now, and I get, the NCAA and their PR machine, they're phenomenal. They're really good. Berman's going on record. He's very calculated with his words, right? Like, hey, everyone's going to have a chance. Everyone will have a chance to get their spot, right? And everyone will have a chance, right? I mean, like, he knows what he's saying, right? He's not saying everyone's getting their spot back. He's saying everyone will have the chance, right? And schools might as well offer everyone the chance at $1 million. Everyone has a chance, right? It's up to the school's discretion. They're not going to give it to anybody. But anyways, the point is, like, no one saw it coming. No one saw roster limits coming. No one saw the number. I mean, I'll say one more thing on this. Okay, so like the judge, April 14th, the NCAA files their proposal after the hearing, right? Hey, we're not going to grandfather. We heard you, Judge. We heard your suggestion. We're not going to do it. The judge gives the objectors 24 hours. 24 hours, right? 120 letters come in 24 hours. When was the last time, like, you were able to rally, like, the PTA board at your school to get something done within 24 hours, right? They got 120 letters in there. The judge had no idea what to do with them, right? She had no. She literally, the document clerk saying there, Judge, I've got 100-something emails from people. What do I do with them? And then you get this order. Once that order hit, where the judge was like, hey, I'm going to docket these things, but, like, please, guys, no more. Like, public, please stop sending me. Like, I knew this was probably going to end favorably for the objectors. But anyways, yeah, just shout out to that group. They have like hundreds of people, like, on their email list, whatever. I mean, the NCAA, I think, needs to be a little careful here, because if there's another, like, opportunity for the public to tell Judge Wilkin how awful their proposal is, they're gonna take advantage of it.
There's actually another letter filed today, so
yeah, I did see that. That was a head scratcher. That was weird. That was a weird one.
Yeah,
it was by a law firm, which, like, look, if it was like just an individual, like, whatever law firm filed it, and it just, like, was factually wrong and made no sense.
If you look at the last names, I think the lawyer who filed it is the parent of the athlete in question. So I think that's part of it. But yeah,
okay.
I mean, not a lot of research, like saying, it's already been given a final approval. No, it clearly has not.
Yeah, that's just wrong. But yeah, I didn't post that one because I just thought that it was was weird.
So we're half hour in, just so everybody knows, if you're just joining us, we're going to be going another half hour. I'm going to get to, mostly the rest of the show will be comments and questions. We want to get to as many of these as we can. We know we have a lot of concerned citizens, parents watching right now, wondering what they need to do to protect their player. And maybe a lot of people have questions that they simply haven't gotten to answer. I have one process question before we get to those. What happens, not after, if it is or not approved tomorrow, but what happens once it finally is approved? Something eventually will be approved. What happens to all of these objectors / pending lawsuits that run the gamut? I mean, you still have the North Dakota State lawsuit out there saying, we're a small school, you can't force us to pay Ohio State's NIL money, and you're talking hundreds of those different objections. What happens next?
So the North Dakota lawsuit actually settled about a week ago.
Okay,
a week and a half
they
ago.
weren't the only one that did it.
Yeah, I mean, there was also a lawsuit way back when that already got dismissed and already got voluntarily dismissed by Houston Christian University. Okay. We haven't seen any similar lawsuits. I kind of figured there would be more, but I think what the North Dakota Attorney General was able to accomplish in that lawsuit with the settlement, it really seems like the NCAA is going to be kind of opening up their war chest to be able to kind of reduce the burden on the smaller schools. So I think that's done and settled. I think the concerns of a lot of these smaller schools, a lot of the G5 schools and FCS and Division one AAA schools are probably eased at the very least. Maybe they're still not happy, but I don't think we're necessarily going to see another lawsuit on this. But yeah, kind of to your question, like what happens, kind of after, what is the process after the settlement is approved?
Right.
Yeah, I mean, the settlement's set to take effect on July 1st, assuming it gets passed before then, assuming it gets approved before then, which if it's going to get approved, it'll definitely get approved before then. I think that's a strong bet at the very least. And yeah, I mean, once a settlement is approved, once the settlement's finalized, the case is closed. So there will, I'm sure, or really, I think it depends a lot on what happens tomorrow. But I would venture to bet there's going to be appeals. I think depending on the appeal, it might not go very well. I mean, it's what we call in law an abusive discretion standard, where the appellate court wouldn't necessarily be able to look at. And Phil, please correct me if I'm wrong on this. This is kind of just my understanding of it. Where it wouldn't be something that the Ninth Circuit would be able to say, okay, was Judge Wilkin correct in doing this? More like, was it unreasonable for her to approve the settlement given all these conditions? And so, it's possible that the Ninth Circuit could step in here. It is certainly possible, but I don't know. I think it would be kind of a high road to get there. But I imagine we'll see a lot of lawsuits after this. One of the issues is that we have kind of this very broad release that's in the settlement, which is the reason why they can do a salary cap, which is the reason why they can do all these different things, roster limits that otherwise might be questionable under antitrust law. It's because the athletes kind of being part of the settlement, as part of the kind of these plaintiff classes, give up their rights to file lawsuits over kind of things that are in the settlement. That's one of the issues, but that's one of the kind of the key parts of the settlement. That's one of the reasons why the NCAA is willing to do it in the first place. So they can get, even if they're not getting kind of the congressional antitrust protection that they're still seeking and still going to continue to seek, they're at least getting some protection from at least what's covered in the House settlement, where we don't have athletes suing over the salary cap. We do have a number of athletes who did opt out. Several, I think a few hundred athletes who have opted out, and they have filed their own lawsuit. They've kind of joined with with plaintiffs who had filed another lawsuit a few years ago, fought no v. NCAA in the District of Colorado. That, if the settlement gets approved, it'll just be for damages. It'll just be for back damages. It's essentially just becomes those athletes saying, we're not getting paid enough in this settlement by kind of the normal process. We're going to try our chances to file a lawsuit to get more money coming our way, but it wouldn't be able to do anything to disturb what we call injunctive relief, which is the rule changes.
They're the opt-outs. They said, we
Yes.
don't want to be parts. Okay. All right.
Yeah.
Philip, you want to add anything to that?
Yeah, I just, look, in terms of roster limits, what I think most folks are interested in, I mean, once the settlement's passed, it's probably the end of the road. I'll be honest with you. I mean, I think there's going to be some emergency appeals. There's going to be a motion to stay, probably. Like if it's, I mean, we'll see, right? If it's not what the objectors want, I suspect that something's going to happen. But as Sam mentioned, the standard for granting a stay, I mean, I'm getting really legal. It's very high. You need to show a lot of things like irreparable harm, and very, very high bar. And so it depends on what the NCAA proposes tomorrow, what the parties propose tomorrow. I see a lot of comments in terms of like, what we're going to see tomorrow. I think if it's okay, Nathan, just jump into that. Like, what?
Go ahead. Yeah, please. Yeah.
Yeah. What I think they are going to do tomorrow is give schools the option to, I imagine some mechanism where schools can decide on their own unilaterally, like, okay, well, this player right here, we cut this player because of roster limits. This player right here, hey, sorry, we just didn't like you, and gives them the sort of broad discretion. And then, for those who are cut by roster limits, I think it'll give them the option whether to keep them on the team, and they can exceed. They'll be able to exceed whatever the roster limit is in the settlement, right? So football teams, they currently hold 130. I mean, most teams have left, right? That's a problem too, right? Kids have left. Kids have gone in the portal. I saw a report today saying that the proposal tomorrow will allow kids who have left the school to be grandfathered in at their new school. But it's like, does the new school want them, right? Like, or I don't know. So yeah, how it's going to work tomorrow. That's how I think it's going to work. I don't think it's going to be a phase in like, hey, in 2026, a team can carry 130, next year 125, and get you down there. I just think it's going to be, what I've read, what I've read online, it's going to be some thing where the school gets to decide if we get to keep you or not. which is not what the judge ordered. But we'll see.
Yeah, shout out to Ross Dellinger of Yahoo Sports and Brandon Marcello of CBS Sports. They've kind of been able to get some comments on and off the record, including some of the leaks of what is allegedly being planned. I mean, we won't know for sure until we actually see the document tomorrow or sometime after that. But I think Phil is reading the terrain right. I think, kind of putting all the puzzle pieces together, that's what it looks like. Schools will be able to kind of designate certain athletes as being kind of grandfathered into these roster limits. Phasing in seems like something that's certainly not going to happen. The grandfathering seems to be the way to go. And it'll really just be a question, I think, as Phil kind of referred to. Is this something where Judge Wilkin is going to accept something that's kind of a half measure that doesn't really completely solve the problem? Is she going to be willing to accept a compromise, or does she really, really truly, kind of insist on the NCAA kind of rolling back all of everything that's kind of happened and offering schools or offering kids, for example, the chance to transfer back, or potentially even, like I wrote an article for Matt Brown's Extra Points newsletter about this. Like, what about the athletes who have lost their eligibility over this, where they've had to transfer in the middle of the season, or their season's been significantly disruptive? Like, I think there's a lot of elements at play here, and I think the NCAA is going to try to, as much as possible, just scratch the bare surface of this, and it's really just going to depend on whether Judge Wilkin is going to be willing to accept that.
So I'm going to follow that on, and I will get to your comments, I swear, but this is one that's been chewing at me for a while, so I wanted you just said it right there. What is the relief that these players could demand? Compensation to move back, all of the expenses that went to if they were released and then they're brought back. Who incurs those expenses? Could backup center place a lawsuit against the school for not either bringing them back or not giving them money to get back? How does that part of it work?
It's a really good question, and unfortunately, the answer I think I have is just I don't know. Like, is that something like could these athletes file a lawsuit over this? Could these athletes file a lawsuit to try to get damages from this? Maybe arguing that even if the settlement's rejected, even arguing that they were told too early that the settlement wasn't approved yet.
Right.
I think it'll really just depend on how any future judge interprets kind of really anything that happens in here, whether that's something that's going to be included within the release or not. It's really difficult to say. It wouldn't shock me if we start to see some of those lawsuits trickle in, but yeah, I just don't know.
Anything else you want to add to that, Philip?
I'll just add the fact that we're talking about having to pay players, travel, come back, and expenses is just a reason why the whole discretionary thing's not going to work, right? You give the school the option, like, hey, you have the option, right, to undisrupt everything that they just argued, was so terrible about grandfathering. Like, no school's going to do it, right? And
I think it's an asinine idea. They started to put these NIL and revenue sharing contracts in place last year. They started doing pro forma contracts just to cover some of these things that we're talking about related to the NIL parts of this, and then to fall back and say, oh, well, we don't want to take the time to worry about roster limits, just put the hammer down and just move forward. It's asinine.
That's the same money.
Yeah,
I think that's the long and short of it. They're trying to cut the budget where they can, and this is the way they've identified as the best way to do it.
Yeah. That's ridiculous. Okay, we've got 15 minutes. I'm going to get to as many of these as you can, and then after you guys take off, or you guys can stick around if you want to after the top of the hour, I'm going to do another half hour of Q&A with everybody just so they know I am paying attention to them. But first, I want to start with this from Rob Ellen, a valuable member of the Mafia family, saying, why is NIL tied to the athlete at a particular school and college and not in the NFL? He's asking, is that an antitrust issue?
I don't think it's an antitrust issue. I think it's honestly just the fact that NIL in college sports isn't really exactly NIL. Like, you've heard a lot of commenters kind of talk about like true NIL versus fake NIL, and kind of the idea of true NIL is doing an endorsement deal, like Caitlin Clark doing a deal with Gatorade, for example, where she gets paid to endorse Gatorade. That's not really what's going on in college sports when you think about NIL. Like, certainly there's a lot of it. Like, there's a lot of college athletes who are doing kind of these true NIL type things. I don't mean to discount that at all, but I think what you're seeing being called NIL is not really NIL. It's just salary, and that's why it's tied to the school. It's because it's, it's just a way of saying salary without trying to skirt the employment issue.
Yeah. Absolutely. You want to add anything to that?
It's only because of the NCAA's rule, right? The NCAA has a rule that says no pay for play. The NCAA got rid of that rule, you'd suddenly see NCAA align with every other sport, right? Everyone will start being honest about it.
Yeah, that makes sense.
By the way, it's kind of funny if you read these NIL contracts, like they say in there, like this contract is explicitly not pay for play, and there's another clause a few lines down that says, we the school can adjust your salary based on your playing time. If you're not getting enough play, if you're not getting as much playing time as we expected, or if you're performing better than expected, we can adjust it up and down. So it clearly is pay for play. It's just not pay for play.
Yeah, and that's a whole separate show. I think we don't have enough time to get into NIL, and we'll have to schedule something in the near future for that. But a lot of new people watching tonight, certainly followers of both Sam and Philip. I encourage everybody to subscribe to our channel. We cover this all the time. We're not just a talking head show. I do interviews with some pretty important people, and these two being a couple of the key components of that. Very expert advice. Nobody wants to hear me talk. I bring them on to ask them good questions and hopefully answer your questions. So make sure you subscribe. Make sure you follow both of these guys on Twitter. You can find both of them underneath their names. You can see it right there in their pictures. And last but not least, don't hesitate to reach out to them if you have questions or comments. That's how we met, and they're very kind and willing to answer questions. Certainly on a show like this, we can't get to as many questions as there are. So I would encourage you guys to reach out to them on Twitter. If you have a concern or a question or something you want to really take up with them, send them a note, and they'll get back to you.
Absolutely.
All right.
Please do reach out if you have questions.
MBM Moen, I was going to do this at the end, but Moen's driving he's the classic backseat driver here. MBM, a valuable member of the Mafia family, $20 super chat, saying, I tailgated with Bronco fans in 2017 when they came to Stillwater, and they were just as nice when I went to the game in Boise in 2019. They would fit very well in the Big 12. Their stadium needs some upgrades, but that's it.
Hard agree on the stadium needing upgrades. And that's not even something like, that please don't see this as an attack on our wonderful athletic department, our wonderful athletic director, Jeremiah Dickey. They've done amazing improvements to Alfredson Stadium. They installed, a giant video board, a great sound system. Just the concourse space is so incredibly tiny. It is so hard to move around in there. It's so hard to have like good food stands or anything like that in there. Like I really emphasize with them, because like that whole stadium needs just a huge remodel to try to get more of that. And they're remodeling the north end zone, which I'm really excited about. Not that I'll personally be able to afford it, but it's not for me.
Yeah, you're not the only one.
But yeah, I definitely see what you're saying on that.
Roster limits. Welcome to the show. I appreciate it. Make sure you subscribe to our channel. What about the athletes who have been recently told they are cut due to performance?
Yeah, I can. I mean, I try to think that people are nice and do the right thing. I have this feeling inside of me that there are cuts happening where coaches are, telling kids that it's due to something other than roster limits, because there is a fear that Judge Wilkins is going to bring the hammer down and give the NCAA schools one choice, which is to bring everybody back who you cut because of your premature implementation of roster limits. You're going to bring them back on teams. So I think,
right.
I mean, look, if in the abstract, look, kids can be cut for any reason, right? They can be cut because the coach doesn't like you. But it just doesn't pass the smell test, right? With everything going on, for a coach to tell a player, you're being cut for performance or budget or whatever else, just to me strikes me as poor form.
Yeah, and it wouldn't shock me if we see something in the in the brief tomorrow, kind of justifying kind of the voluntary part of this, where they're the plaintiffs and the NCAA and the conference defendants are making the case where it's like, well, under NCAA rules, athletes can be cut for any reason. It's it just kind of inherent right of coaches to be able to control their rosters, and that's
Right.
true. That's 100% true. And I imagine that's going to be kind of the point that they're going to push to say, hey, we can't make this mandatory. It's not something we can do to have mandatory kind of rollbacks of all these things, because ultimately we give the coaches the power to kind of control their rosters, and we have to kind of respect that power.
Yeah, okay. The biggest question for me, right, is so you have a lot of kids who have already been cut, right? Her order acknowledged it. She said multiple times there have been many class members who have already been harmed. Okay. And so the proposal tomorrow is going to look like, I mean, to be clear, I haven't seen it, but this is just what I expect it's going to say. Exactly what Sam is going to say is that, we're going to make it optional. It's always been in the discretion of the coach. But you get this problem, like I'm trying to think of what like the right legal doctrine is. It's not fruit of the poisonous tree. It's not like maybe it's like but for causation. There's this dilemma, right, where like suddenly like we just have to trust the coaches, the schools, that like the person who was cut 6 months ago like wasn't cut because the Rosh limits was cut for something else, right? Like after they just told the judge how disruptive it'll be to undo all the damage. And so it's just like, had they started out with this proposal in the very beginning, and schools and coaches didn't start doing, I mean, like, yeah, I think it'd be a lot more defensible. But to come at it now after you've lost twice, and then like, Judge Wilkins says, don't harm people, and your response is like to amend the agreement that like, to give yourself the option to like have like, to go back in time to like cure your own, conduct. It just, to me, just doesn't pass the smell test. Like I'm trying to think, what's the doctrine for it? Like if someone out there like knows like what I'm talking about, like it just, it just doesn't sit right.
I think it's a bad faith argument.
Bad faith, for sure.
College sports has always been bad faith, though. I mean, it's all been about money, and it's been about power. And I don't think that certainly doesn't get reinvented with the House settlement, right? It'll just continue to be the same thing going down the road. So, Mary Ellen Androsky, welcome to the channel, Mary. I hope you subscribe. Make sure you follow all of us on Twitter, and give us a thumbs up. Leave us a comment or question. We do get to those. What is the chance that Judge Wilkin will reject the proposal and this goes to trial?
So those are two different questions, because I think there is a possibility that she rejects the proposal, whatever is kind of put forward tomorrow, and the plaintiffs, the parties come back and say, "Oh, give us another chance to amend this, even if you're telling us that we're going to go to trial now." I mean, they can always come back and continue to kind of try this, at least to my understanding, at least, yeah. So I think that's a possibility. But, kind of for the first part of the question, like, what are the chances that Judge Wilkin will reject the proposal? I think I'll wait to give a firm answer until I actually see the proposal. And even then, it's hard to be sure, hard to know what Judge Wilkin is kind of thinking that, about this at any given time, aside from kind of what we know from this order. I think at this point, we're looking for something, we're somewhere pretty close to 50-50.
Wow. 50-50. That's remarkable at this point, I think. Go ahead.
I pin the chances of her denying it like a lot higher. Like I'm at like 90-10. I mean, just wow. Based on what I've seen in the order, and just putting, look, I've been drinking a lot of the Kool-Aid. I'll admit, like I've been hanging out with a lot of the no roster limit crowd, but I just like, just putting myself in the shoes of a judge. She has shown she's very honorable. Right, she came out, gave the NCAA the opportunity to do the right thing. Like she could have, told them legally they had, gave them the opportunity to save some face, do the right thing, and they came back and said no. And I thought she brought the hammer down on April 23rd. That's like her version of bringing the hammer down, right? Like just like a really strongly worded order. And I could see something like this just really ticking her off, to be honest with you. Again, we'll see what the parties say tomorrow. I just just based on what I've seen and what I've heard, just reading tea leaves, it doesn't sound like the objectors were given any voice at all. Like Berman in his interview today was like, yeah, I think they might reject it. I'm sure they will, right? Like, well, did you ask, right? Did you ask the objectors before you went to, the do your interview today? So I think the chances are pretty high. I think they have the real proposal, like, in the briefcase that, like, after Judge Wilkin rejects it, they'll be like, okay, Judge, we handed you the wrong one. And
that's very possible.
Here's the right one. Give us another chance to give you the right proposal. That's just where I think, again, like I mentioned earlier, like everyone's freaking out because, the NCAA keeps pushing back and fighting back, but like the objectors are winning. They are winning. It's like crunch time in the fourth quarter. It's a 2-possession game with 4 seconds left in the fourth quarter. So I think the chances Judge Wilkin reject proposal are high. Chances go to trial are like 0. I think 0.
Okay.
It's too much at stake to go to trial.
Yeah, it's it's a lot of money hanging out there, and then the potential for liabilities is just getting longer. It's not getting shorter. So
Yep.
I definitely think both of you guys are on top of that for sure. Conundrum. Welcome to the show, Conundrum. Good to see you again. Who is representing the interest for future athletes with House versus NCAA? Are they not entitled to their own negotiations, RE, NIL, and salary? And I would just say that's tied to the federal antitrust provisions that they're also arguing for in Congress. Isn't that right?
Yeah, to a certain degree. I mean, the NIL salary part of this, that's kind of a different negotiation, a different discussion, than what's going the broader House limit or House settlement, because the House settlement is very much a macro type thing. It's very much looking at kind of setting broad rules for the entire NCAA. So, like, they are all like the future athletes are all certainly entitled to have agents and to do their own negotiation for their own NIL salary. But who's representing the interests of future athletes in the House? In the settlement, that's actually been a source of contention, because that's one thing that a lot of objectors have pointed to and said, hey, there's a massive conflict of interest here. There's this conflict of interest between the named plaintiffs in here who or not even necessarily the named plaintiffs, but like the future or the past athletes, the athletes who are just getting damages, who have a pretty strong interest in getting the deal done because they get paid and they don't necessarily care that much or have a vested interest at the very least in, whether there are roster limits or anything like that. And the future athletes who are not going to get a dime of the back damages because they haven't been in the NCAA yet, but they're going to be affected very heavily by these roster limits. So that's been something where Judge Wilkin has kind of questioned the plaintiffs on this several times, like including during the final fairness hearing. The plaintiffs' attorneys, at least to my eyes, didn't have a particularly good answer for this. It's something that Judge Wilkin kind of looked at them a little side eyes on. Their kind of response here is that one, Sedona Prince, who's one of the named plaintiffs, a women's basketball player at TCU, she is a current athlete, or at least is currently a current athlete. She won't be a current athlete very soon once she graduates this semester. But so she can represent the current athletes, and their proposal as part of the settlement, they would kind of bring on a new athlete to kind of represent the future athletes every year moving forward, which is kind of a strange kind of thing, and kind of, well, for one, it kind of speaks to kind of the nature of class action settlements, where or class action lawsuits, I should say, just in general, where it's kind of this interesting dynamic where a lot of the times, and you're seeing this to some degree here, a lot of the times, and I don't mean to say all the time, but it's not necessarily, someone hires a lawyer and the lawyer represents their interests. It's almost kind of flipped in the class action setting some of the times, where the lawyers seek out clients and kind of use it to kind of kind of go after kind of these broader changes or these broader kind of damages suits. Hope it didn't just
no, that sounds fine to me. Philip, you want to add anything to that?
Nothing to add. I just was laughing. I saw this comment from BYU football. It's just hilarious. Love it. Don't look at it. It's
okay.
Shout out
Shonsky's a troublemaker.
Shout out to my alma mater. It's a funny one, man.
All right, we'll just get to a couple more. Chris G. valuable member of the college football mafia family. Good to have you here, Chris. How could they institute a salary cap? With the cap, would you need a roster limit?
So yeah, the salary cap that's part of the House settlement, the 20.5 million that's kind of been bandied about. The only reason it's allowed, it would be something that, but for kind of being outside of the settlement construct, and it's not even 100% certain that it's even legal in the settlement context, but for kind of that settlement context would be very much an antitrust concern because it's limiting the amount of money, limiting kind of the competition in this labor market, the economic competition in this labor market. It's allowed, or at least hypothetically, it's allowed because it is in the context of the settlement. As I kind of mentioned earlier, athletes are kind of, as part of these classes, giving up their rights to file lawsuits over things that are in the settlement agreement. So they would not be able to sue, including over antitrust, over the salary cap.
Okay. You want to add anything to that, Philip?
No, that's exactly right. This is a salary. They are implementing a salary cap. If the question was how do you do it like the right way, I think we start talking about collective bargaining and all that stuff. But I think that's a whole nother.
Yeah, we're fans around that. We want athlete protections around here. At least I do. Anyway,
long road to get there.
We're gonna have one more question, and then we'll let you guys get out of here. I want to invite everybody to stick around. I will be doing Q&A after this. You guys don't have to leave. I'm not going to kick you off, but all you have to do is hit X, and you can take off whenever you want.
Nathan, let me just say one more thing, Nathan. I just saw a comment here about the class of 2025 and is Blue Ridge Titans baseball class of 2025. I suspect tomorrow that the incoming class of 2025 will be included in this proposal. I just if you look at the hearing transcript from April 7th, Judge Wilkin, to me, very clearly, like I don't think she is I mean, obviously sports got to be a sports fan, right? Knows the law very well. I think the lingo got a little bit lost on her. Technically, right, incoming high schoolers don't have a roster spot. They're not on the roster yet. They're not even enrolled at the school. But just based on what the comments she was saying at the hearing, it appeared quite clearly to me that she thought that incoming recruits who had accepted an offer have a roster slot. And she said that several times. And so I suspect that if, like you guys heard from Gracelyn Laudermilk and Gracelyn at the hearing, she's an incoming 2025 recruit. I mean, if the proposal doesn't protect her, I mean, Judge Wilkin's gonna lose her SHIT.
Well, if she knows her by name, that's definitely a protection, I think.
Yeah.
Blue Ridge Titans baseball asks, thanks, Phil, for mentioning that it doesn't just affect walk-ons as many.
Yeah, I think that's what Phil was just responding to.
Oh, is that the one you're asking? Okay.
Yeah.
No, that was a different point. I mean, I think this point right here is that it's not just walk-ons being cut. It's a common misconception that like you won't believe the number of just like sort of like uninformed comments on social media about like, oh, like who cares about walk-ons, right? Like let's whatever. It's not just walk-ons. I mean, it's absolutely not true. You get injured, like, and that's the point that Gannon Flynn was making at the hearing, right? You get injured, you're on the chopping block, right? Even if you're on scholarship, partial scholarship, if you have a down year, your mental health's not doing well, or you're doing amazing, and this international athlete is, being, on the market, and the school wants to make room for that athlete. Someone's got to go. So it's not just. I think this comment is just that it's not just walk-on athletes. It's everybody unless you're a superstar.
Okay. Yeah, I think when it first came out, I can't remember the show that it first came up. I believe when the House settlement was initially announced, people were looking at roster limits as a way, at least at the time, the perception was it was to get all these teams on the same page. BYU carries something like 130. Ohio State's over 150 athletes, right? And there always seemed to be, you could take 3 and 4 and 5-star athletes and put them on the 2 and 3 deep. And the idea was, at least my perception was, it was a fairness issue. They were trying to true that up and make those things. So now you have better athletes going farther down into the system. As time went on, it completely changed, right? The narrative completely changed. And now we are hearing a lot more over the actual damage that it's doing to the players, not only that are currently on rosters, but we're either going to never be offered a roster slot in the future, or we're going to be cut back and basically left to fend for themselves. And I think that part of it, there was part of a communication campaign to sort of cover up really what the damages for roster limits was going to be. Isn't that what is that? Does that come across like the same thing for you guys?
Yeah, I think
Like
that's a
the
good
PR
summary for that.
machine. The
Yeah,
PR machine of the
exactly.
NCAA is incredible. The schools, they're amazing at what they do. The NCAA put this like ad out like a few weeks ago talking about how a player was honoring his brother who had passed away, and then conveniently said, "Hey, this guy went from walk on to scholarship player." No doubt in my mind, they tied those two together, because how do you criticize a post that's talking about the guy the kid's brother? It's tragic. And the PR machine is amazing at those institutions. And, they certainly, and this is sort of the point I was making earlier about, the no roster limits group, right? They went up against this machine, right? For the longest time, you heard in the news, the narrative that like so few people are getting cut, and just, they did a great job of exposing that.
Yeah. Sam, you want to add anything to that?
Nope.
Okay. Really quick, I want to get 5 new members. Moen gave out 5 new memberships. I want to thank those guys for being here today. That would be Fearfully Confident, John Grove, Brett Taylor, Braska Rascal, and Jay. Welcome to the College Football Mafia Network. Most of you guys I recognize. We do have a members only video or show on Thursday night. It's going to be around the University of Miami and where they may end up with the ACC and Big Ten and SEC. Lots of people are concerned about those schools in the ACC, and Miami is one of those guys that carries the water. So I'm going to invite everybody to tune into that. I believe it's at 8 p.m. Eastern. Moen, correct me in the comments if I'm wrong. But that's a members only video. So those new members, you guys got memberships, make sure you tune in. Other than that, if you're a new viewer, make sure to consider becoming a member so you can watch those new member videos, and then obviously our library of videos. Let's see here. I'll get to a few more questions. Jackie says, and Jackie's been very concerned in the comments. I've been reading these. Everyone agrees that student athletes can be cut via normal circumstances. No one is arguing that. What we are arguing is that 5,000 kids who are estimated to be cut because of the limits.
Yeah, and I think that's a big part of it. Like these are athletes that the coaches don't even want to cut. Like that's what really strikes me about like all these. That's what really struck me in a lot of these letters, and it's like several of these letters where the athlete's saying, "Hey, my coach told me that they want to keep me," and like I was at a meeting with some coaches here at Boise State, and they were saying they don't want to make these cuts either. And like even if you look at even some of the comments about like some of these roster limits, some of these limits that they've drawn are just way too tight. Like there are major injury concerns here. There are just several issues concerning like just what you're going to do if players get injured and fielding a complete roster. Like it's kind of crazy how this has happened, and the fact that you're kind of forcing it's coming from the NCAA, forcing these schools or forcing these teams to cut all these athletes just all at once with kind of no regards for anything, for the service that they put in. That to me is really what struck me about this big issue. Like, yes, coaches can cut athletes under normal circumstances. That's totally understandable. Like being cut is part of the process. Like I saw a comment about that in the chat as well. And that's entirely true. Like sometimes, failure is part of the process. Sometimes you get cut. Sometimes you need to go to a different program. Like sometimes the coach wants to kind of bring in their own players, bring in their own Gucci bag. Like it happens. It does. The issue for me is like having kind of these mandated cuts that are just out of nowhere and are really kind of just not giving any kind of explanation.
Yeah, I completely agree. Philip?
Yeah, no, I agree. I've got to drop you guys. I got to pick up my son from baseball.
Yeah, I was just gonna say, why don't you tell everybody where to find you? You were 20 seconds ahead of me. I apologize.
Yeah, find me on X, you guys. Folks have reached out. I try to respond to people the best that I can. I don't have all the answers, and I just happy just to talk you through stuff. I can't represent anybody to sue. My firm is conflicted out. I tried very, very hard. I took it all the way up to the tippy top to, let me jump in the ring and file on behalf of some objectors. So I can't, sue anybody, but, I could put you in touch with folks who I know are, trying to plan something like that. I'm not involved in that, but I can refer you to folks. But yeah, Nathan and Sam, it's a pleasure. Thanks for having me. Sam's great chatting with you again. And we should do this again. We'll see what they have tomorrow, what they serve tomorrow. Maybe after the objectors file their briefs, we get together again. But Nathan, man, this was awesome. I appreciate you having me.
I appreciate you coming on. Thank you so much. And go ahead and take off, Philip. You take your time, get to your family. And
right.
for your viewers, both you and Sam, this video is recorded, right? This is live to tape on YouTube. Just all they have to do is go to that link and they can watch it again. Feel free to cut up the video as you need to, repost individual links. I know some of the stuff that you guys are really caring about, you can cut those into smaller pieces. So don't be afraid to do that if you need to.
All right. Thanks, guys. Bye.
All right. Thanks, Philip.
Thanks,
okay,
Phil.
Sam, why don't you do an outro really quick?
Sure. Yeah. Like I said before, my name is Sam Ehrlich. You can find me on Twitter at Sam C. Ehrlich, SamCehrlsch is my name with the C in the middle. I'm also on Blue Sky under the same handle. One thing I forgot to mention at the jump is I have a website, the College Sports Litigation Tracker, which has a bunch of information. I've tried to kind of collect all the important documents and things from not just House, but a number of different cases that that the NCAA is involved with, or NCAA institutions are involved with. Kind of any case that I feel that really could potentially change college sports. Like everything, I try to keep everything on there, and it's entirely free. I'm not looking to make any money off of it. It's just kind of there as a resource. So definitely check that out if you're interested. collegesportslitigationtracker.com. And yeah, thank you so much for having me.
You bet, Sam. We will do this again. Feel free to leave that web address right in the comment section.
Sure
People can go to it and get to it. Okay.
Yeah, and if there are any questions that weren't answered, that is something that you're looking to me to potentially answer, feel free to reach out to me. My voice state email is very public, so you should be able to find it with some pretty easy searching. But it's also just Sam Ehrlich at boisestate.edu, so that's easy.
I really appreciate your time. This has been a ton of fun. There's never enough time to go through all the questions, but we will do this again soon. Okay.
Of course.
Okay. Thanks, Sam.
Thanks, everyone.
Have a great night. Okay.
You too.
All right. Look, anybody else get interviews like we do around here? Look, these two guys are some of the smartest people in the business. Legal expertise has nothing to do with my opinions, anything to do with our channel. These guys are resources that I want to give them access to people, and I want you guys to reach out to them. Feel free. You don't have to go through us. But if you do, make sure you like and subscribe this channel. Make sure you let us, pass this on to your friends and family, and have them pop over and do the same. Leave us comments, questions. We get to those on YouTube itself. And this is always a ton of fun. And I'm very grateful to Sam and Philip for being here. This was a ton of fun for me. I was looking forward to it for a long time, and I'm glad we were able to get it in. You heard them both. They'd be willing to come back and discuss. I can't promise doing it tomorrow. Certainly they have way more in-depth schedules than we do around here. But we will get it on the docket. We'll get them back, and we'll do follow-up questions and continue to chase this down. Something we didn't get to as much today that we're also going to talk on in a different conversation is NIL and revenue sharing, and some of the complications that we've seen tied to those things. Tampering is a catchword everybody likes to throw around as well. We're going to talk about those things in the future and really get into the nitty-gritty of what those things actually mean. It's not just ad hominem. People just make them up and throw them out, hope something sticks. We actually try to chase these things down and get to as many resources as possible. So I want to thank them for being with us tonight. I'm going to continue to go through questions that we've got highlighted. I apologize we couldn't get to them on the show with the guys, but I'll go through as many of these as I can and try to answer as many of these as I can, knowing that everything's backstopped by either reporting or stuff that I've gotten from them in the past. Let's see here. Kathy Brown. Good to see you, Kathy. Thank you for being here. Brown's a great name. Does anyone have the hearing transcripts from April? Oh, I think this was answered later. It sounded to me like Sam, who posted his link in the live chat, has those documents, but there has been other people that have offered to supply those. If you need a copy of those things and you need some help, you can either post it to Sam and Philip on Twitter, or you can simply ask here on YouTube, and usually people are kind. If they have access to them, they will supply them to you. John Bayheim, good to have you here, John. Thanks for coming. What happens to this settlement if Congress grants college sports antitrust exemption? So they're two separate things. We're talking about civil litigation here, and this is a settlement between the NCAA, the A4, which is the autonomous 4 leagues, Big 10, SEC, ACC, Big 12, and them moving forward to get the revenue sharing and the NIL money part sorted out. The antitrust exemption is for ongoing lawsuits afterwards. And yeah, they're trying to ramrod through some solutions that honestly, everybody that I come in contact with, if you're a fan of the antitrust exemption just for college, just so that things will tamper down and it'll control stuff, that's not what it is at all. If they win antitrust exemption again from Congress, it will basically be recursive. So everything that's come forward, paying athletes and everything that helps them to pay them for what they've earned, it could all be rolled back. And nobody wants that. I think the A4 might want it. I think the NCAA might want it, but that doesn't do the players any good. And so I'm highly against it. I don't have a problem sharing my opinion about that. So I think we will continue to monitor the antitrust exemption. But right now, something like that would have to be instituted by Congress. I've asked around, and nobody has told me that an executive order could institute antitrust exemption. That's not how it works. That's not really what the purpose of the executive orders are usually even supposed to be for. I'm highly against an executive order at all. Never mind Nick Saban and he goes golfing with President Trump. I'm not getting into politics tonight, but I would just tell everybody that listens to me, I would be telling you to cheer against an antitrust exemption, and what they should do is a CBA or some sort of employment contracts, something for these athletes to get paid. Then you can start talking about things. If you put a CBA in, then you could institute further maybe salary structures by player. You could do them by position like they do in the NFL. But it gives the athletes a chance to collectively bargain and get what they need to, like healthcare and some other things, their protections as well. So, but yeah, they're two separate deals. Antitrust is not tied at all to the House settlement. Connor, good to have you here, Connor. Thank you. Make sure you subscribe and like the show. Do roster sizes change while this case is going on, or is it official? Only official when it gets passed. It's only official when it gets passed. It's never supposed to have been something that Judge Wilkin never intended for the minute it got passed. I believe it was April last year when she put out her first preliminary approval. Roster limits were never intended. And NIL agreements were never supposed to be structured around this deal until it was finally approved. She never intended that. She's on record saying she never intended that. So nothing is official until it's official. The A4 conferences, the biggest conferences in the land, and the NCAA wanted to institute these things for greed. They want to cut costs. The easiest way to do that is shrink roster sizes. Now, I don't know why they should want to get rid of walk-ons, because as far as I know, they're not paying walk-ons. That's the whole purpose of being a walk-on. They don't have scholarships. So I don't know why that even became a part of it, but it's there now. And I know both Philip and Sam answered this, but in my opinion, I don't think the judge is just going to stamp this approval tomorrow. I think these guys, everybody that is in this lawsuit, has tried to basically strong arm a federal judge. And honestly, I have never heard of that in my life. I haven't talked to one lawyer, two tonight, that have said, yeah, that's common. You're basically playing chicken with a federal judge. That's crazy. And in my opinion, the NCAA is one of the most corrupt organizations on the face of the planet. So that everybody knows where I stand anyway. Anyway, Connor, thanks for your comment. Let's see, Jackie, the schools are setting aside $20 million for athletes, 20.5. The schools that cut kids early should pay for them to return and reduce that amount from their $20 million. It was their own doing. It definitely was their own doing, Jackie. You're exactly right. And yeah, I don't know what they're going to do about the costs incurred if, she says, no, you have to bring those athletes back or something of that sort. I don't know what that's going to look like, but it's ugly. It's ugly, and they did it to themselves, and they're asking the judge to basically pat them on the back and say it was okay what you did. It isn't okay what they did. It hasn't been okay for a very long time. But that's where we are now. Let's see here. William Wilson. Welcome to the show, William. Does the House waiver imposed on players include a waiver of any state law claims of employee status? It's a federal ruling, William. The antitrust thing, the House settlement is a federal class action suit. So as far as I know, that doesn't waive states' rights. I could be wrong. I haven't asked that question in a very long time, and I honestly might be misremembering the answer I received at the time. And maybe somebody should go on Twitter and don't send a DM, just open a general question and copy Sam and Philip and ask them. My memory tells me, and I'm getting older and I'm losing lots of stuff, but I was told that state lawsuits could still happen. Now, I don't know who you're suing in state, because you're talking about a transnational civil case that would be going against it. But I don't know. Somebody needs to check that with the lawyers in the House, and there's a bunch of them on Twitter. Ask any of them, Mitt Winter, I mean, Christy Dosh, Ryan Peeble Mulvaney, the list goes on and on, all friends of mine. And ask them directly. I don't know the answer to that question. I'm not going to. But I thought I recalled that state lawsuits could still happen, but I could be wrong. And I'm willing to admit I could be wrong. Shooter, Texas. Good to have you here, Shooter. It's good to see you again. Remember when college football was about football? Boy, I want those days back. I'm sick of this NIL and ESPN money crap that is ruining college sports. Well, to be very clear, though, Shooter, let's be fair. Money has always been there. The only difference now is it's all above board. So you're a Baylor Bear. I know that. Baylor has a better opportunity to be successful now with who is a fairly well put together set of graduates out of Baylor that have a little bit of money to be able to buy stuff with dollars, right? NIL spending. And you have every opportunity to spend big dollars for best talent. 20 years ago, hell, 5 years ago, if you did that, the NCAA come in and give you the death penalty, right? They'd shut you down. Now, it didn't happen to many schools. SMU obviously was 40 years ago, but now everybody can do it. So while the corruption, yeah, I'd love the corruption to be out of it. As far as I'm concerned, I prefer today to 15 years ago. And that is the main reason, is now everybody can go out, and if they have the resources, they can get the talent. I think it's meritocracy at the very top. If you want to do socialized type stuff, and I'm not saying you are, but if you're somebody that is a believer that the socialized part of all of this, make everybody the same, make everybody fit into this tight little bubble, regardless of resources, then you're just asking people to cheat, because we all know money's out there. Money is not going away. I don't care what happens with House. I don't care what happens with antitrust exemption or anything else in Congress. Money is in it now, and it's not ever going away. So it's better, in my opinion, to manage it than flat out it's like trying to put the ketchup back in the bottle, right? I just don't think that's possible. Could be wrong. I don't think I am, but anyway, that's my opinion on it. But yes, football, certainly without as much money, football was much more enjoyable. I just think that you have a much bigger pool now of schools to be successful. That number 3 years ago, that number was probably every year 8 to 10 teams really were competing for a national championship every year. There's 135 teams. If you take the richest teams, that's roughly half of that, 70, 69, 70 teams in the A4. And that group, in that group now, you probably have opened it up. I would say maybe between 20 and 25 teams now on a given year could compete for a national championship. Doesn't mean they're going to win one, but they could get to a national championship game, to the playoff. The playoff is the equalizer, right? So upsets will happen. They didn't happen this last year. That's not to say they won't, though. The more this goes, the more you're going to have teams that are going to step up and spend the money they need to compete. Anyway, it's great to see you, Shooter. Appreciate it. Let's see here. Sean Ellis. The schools would not need to claim roster limits as a reason for cutting anyone. They just make up another reason so the athlete doesn't say they were cut because of roster limits. Sean, you are exactly right. That is exactly true. And that's actually what's been happening for a very long time. Because it's at will. It's like, I don't know where you live, but Utah's a right to work state, meaning you can be let go for any reason. It's not a union driven state like the state of Washington, where I grew up. Even grocery baggers had to belong to a union, and they couldn't just get rid of you for no reason. So that part of it, in college, I believe the scholarships are year to year. So even though you're given a full ride 4-year, I don't think they're 4-year. I think they're 4 1-year commitments. And then at the end of each year, the school has the option to not pick you up the next year, not give you a roster spot. I believe that's right. If somebody corrects me if I'm wrong, please feel free. But I think that's what it is now. For sure, it's year to year. And so, yeah, they can let you go. I think if you're there for the year and they commit a scholarship, you have to have your school paid for the entire year. But I don't think it's 4 years in perpetuity. I think it's a 4 1-year contracts, scholarships. So, yeah, they could have done that. You know what they've done, though? The reason that they waited for the judge to do it is they don't want to be the bad guy, Sean. The A4 and the NCAA don't want to be the bad guys. They don't want to be accused of being money grubbers, and they're just firing people just to fire them so they can save money. They wanted cover. They wanted the judge to basically underwrite their poor decision making. And I'm glad she didn't do it. I'm so glad. And I want her to send it back like Michael Jordan rejecting, some short guards jumper. I would love her to slap them around tomorrow. It would make my day. Let's see here. NBM Thanks for your $20 super chat, MBM. I appreciate it. By the way, if you want your comment, I'm going to go another 20 minutes. I decided I got a little bit of voice, so I'm going to use it. If you want your comment to be read at this point, it'll probably have to be a super chat. I've got a bunch of live comments that I've got marked. But you're more than welcome to just continue to leave your free comments. No big deal. I do defer to member comments. And again, I want to plug our member video on Thursday night, 8 p.m. Eastern. And they're going to be talking ACC realignment in Miami in the house. I believe Rock and Rant will be there. And that should be a very fun conversation. But that's a members only video on Thursday night. So become a member. You can go watch the members video and then watch our library of members videos. Heading towards an NFL model will yield NFL results on field and off field. I don't know how to answer that. I guess it depends how many teams are in that model. I personally think you could run a 72 team Supra League, and I'm not going to get into my Supra League idea. It's a little different than everybody else's Super League idea. But regardless, I think you can't take the biggest brands in college football, and it doesn't necessarily have to be all the A4. It could be some of the A4 out and some of the G5 in or G6 in if they want to spend the money. Regardless, put that league together, and they can play NFL type, with divisions. You're never going to have anything like a draft or anything like that, but that could work in college. I don't know that you can get much more structure around it than that, though. So NFL, I don't think the professional. The only way I see something like what you're describing working MBM is if they completely break football away and it's its own thing, which could happen, by the way. That's my Super League idea, is you take 72 and then they're not tied to the football conferences at all. They're just the best brands. So we'll have to see. But thanks for your comment. I appreciate it, MBM. It's great to see you tonight. Rock and Rant has been here 15 months, member of the operation here at College Football Mafia Nation. Appreciate him. It's good to see him. 15 months is a long time. I want to thank him for all that he's done for me personally and the channel. And he and Flo, Miami Flow, have their own channel called the College Football Express. Fantastic channel. I'd like to say they're sort of a sister channel to us. Certainly, we do everything we can to support them. They do a great job, and I would like to push everybody over to them. Look them up on X and on YouTube. Can't wait to see how the lawyers for the House settlement figure out a way to literally piss the judge off yet again tomorrow. I would love that. I'm sad it's not a live hearing, right? I'm sad it's like a written thing. I was waiting. That's popcorn television, man. That last one that College Football Express streamed, Rock and Rant ran that. Unfortunately, I couldn't make that show that day, but that's entertaining as hell. That's appointment television. That's like O.J. Simpson fighting for his life in California type TV, watching that stuff happen around college football and college basketball. So it would be great if it was entertainment sport. It's not tomorrow, unfortunately, but who knows? If she sends them packing and says, don't come back to me again unless you've actually done some work, maybe we'll get a live show. I want a show where they have to sit up there and they have to take a line of objectors out the door, hundreds of people that have shown up to yell at them for cutting their sons and daughters. That would be awesome. Give them some like rotting vegetables or something they can throw. That would be a lot of fun. Good to see you, Rock. Miami, Ohio, Florida. Good to see you, Steve. Oh, sorry, Steve, Ohio, Florida. My bad. I need to explain to me the process of instituting collective bargaining and how it will organized and implemented for all college athletes. Just so everybody knows, Steve was, I don't think he's a lawyer, but he did union contracts and those types of things. So he's used to dealing with collective bargaining and employment issues. He and I don't agree on this particular one. I don't know how it could be instituted, Steve. I've told you that. I just think it needs to be done. So where there's a will, there's a way. Doesn't have to exist today to make it work tomorrow. They just have to put in the work to make it have structure. So that's the only response I have to that. But it's not easy. I've never once said it's going to be easy. Iosefa Tuyasau, right? Tuyasu. Sorry if I got that wrong. Iosefa Tuyasau. Man, I love those Polynesian names. I'm just not very good at them, I guess. So what you're saying is that it is unlikely the judge will agree with the new terms presented tomorrow. That's what both Philip and Sam said. Yes. Sam was 50-50 chance. Philip was more like 90-10 that whatever they're proposing, she's not just going to rubber stamp tomorrow. So I don't know if you have a dog in the fight. I don't know if you have a kid, maybe an athlete or whatever, but those parent objections have really gone a long way with the judge. Really, the parent activism in this whole thing has been just completely laudable. They've done a great job. Let's see here. Roster limits again, and interestingly, Texas and Texas A&M turned in the ponies. And what are they spending now? Yeah, Texas A&M. We're tired of getting shown up during the Pony Express days and turned them into the NCAA. But it's ironic because Texas and Texas A&M and Georgia and Ohio State, Michigan, Alabama, these schools have been paying players for decades. Bear Bryant type time, 60s, 70s. So it just went from brown bag men and Corvettes to NIL and whatever. So, but you're exactly right, Ross. That's where that started. I think that's funny. Let's see here. Devil Frog, the OG Mafia member. Good to have you here, Devil Frog. Thanks for being that member. I really, really appreciate you, man. If collective bargaining is a theme, then we need a draft. Yeah, see, that's where I started. The NFL light kind of scares me, just the classification. I still think you could do a super league with the best brands that want to compete at the highest level, that can fund their programs at the highest level without getting into an NFL light draft. I just don't think that's practical. There's too many schools, too many athletes, too many, just too many of everything, Devil Frog. But who knows? Anything's possible until it's not, right? Tempest, good to see you, Tempest. Valuable member of the College Football Mafia family. Glove don't fit, you must have quit. Yes, we're talking about OJ. Boy, those were the times, weren't they? Morris Simmons, good to see you, Morris. Another longstanding member of the College Football Mafia family. Hello, everyone. Go Noles 2027. Florida State has been hitting some baseballs around. They've been good the last couple of years. Well, I think they're good every year, but it's been fun to see them in the headlines. I enjoy tracking all of the FSU fans that are out there that crow about their baseball team. My school goes to sleep during the spring, so I don't normally do baseball cheering, but it's good to see you regardless. BYU football, that's Shonsky, another valuable member of the Mafia family. We want this to pass. We don't want this to go to trial. I don't think it'll ever get to trial, Shonsky. You think the athletes are suffering now? Wait until schools drop athletics altogether at their universities. They are going to have a hard enough time now. I mean, sure, that's one reason. Sure. I need a drink really quick. I think that's reasonable, Shonsky, to think that. But the schools, if they don't, nobody's forced schools to have extracurricular sports anyway. It's all optional, right? No school is forced to have a football team. BYU happens to be one of those schools that loves their Olympic sports, right? That's on BYU. They're going to have to fit that in. to all the money that they want to spend or not spend on athletes. So it's up to each school. It always has been, though. That's the difference. People think roster limits and these other things are just being forced now. No, the schools have always had the option to have. The only thing they had to meet, the only expectation they had to meet, is a 1-for-1 for Title IX for women's sports access. That's the only rule they've really been required to do. And it's not 1-for-1 sport. If you have a women's basketball team, you do not have to have a men's basketball team. It's just you have to have one sport to account for another. So look, BYU wants to save money. They've already got a bunch of club teams. Lacrosse is club. They could push 90% of their sports to club if they really want to. They're not going to, because that's not the mission of the church and the school. But nobody's forcing Utah, for instance, to have whatever they have. So, these schools need to step up and make their own decisions, not wait to be bailed out. Rock and Ran again. No draft. Most kids are never going to play pro. They need to be able to make to take a major they want also, and not every school was what they want. It may be secondary during recruiting, but most not NFL bound. Yeah, I mean it's a 1% of 1% that actually play in the league. Ask Shadur Sanders how that works. Haven't had Fergie on yet. Just time is flying. I'll get Fergie in here and we'll talk some Colorado draft pain. That'll be a very interesting conversation. Trojan Fight, good to see you, man. It's been a minute, but I appreciate you being here tonight. I wouldn't put it past the NCAA to have some sort of lockout at some point. I don't know what that means. Lockout what? Why? I think the reverse. If I was a school, I'd want to get rid of the NCAA. The A4 are trying to come up with their own body anyway, their own enforcement, their own rules, their own championships. So the NCAA is pretty soon going to be a lower division only entity, except for basketball, and that's because basketball is under really long-term contracts with CBS. But the NCAA, I don't think is going to last past this next iteration, the next 5 or 6 years, because the A4, the Big Four conferences, do not want them meddling in their rules or anything else. So, yeah, I'd burn that thing to the ground if I could. I think the NCAA is one of the most corrupt organizations in America. Let's see here. Try to get to more comments people haven't seen. Owen says no draft. That's funny. Ohio State. So, you could wonder why he'd do that. Trojan Fight says Ryder Lyons for Oregon now. I'd rather you guys get him if USC isn't. I hope you're talking about BYU. I would love him to go to BYU, but everybody's sort of putting the cart before the horse. You win Ryder Lyons, he's not going to play it down for you. He's going to go on a mission for the Church of Jesus Christ of Latter-day Saints. He's going to go be a missionary. He could come back and completely change and never play it down for your school. In fact, if I had to bet, I would be willing to bet $10 right now with somebody that whoever he signs with, he never plays for, or certainly doesn't play for in the first few years. I think he's going to go on his mission. He's going to come back and he's going to have somebody else drop a bag in his lap and he's going to be playing football somewhere else. So I don't think I don't think you want to win this first round with him. And that's my opinion. Let's see here. Conundrum says same as a teacher's contract without a union. Yeah, that's right to work right there. Definition of right to work. Let's see. You guys have been fantastic tonight. I apologize. There was only so much time we could get to all the comments and questions we've had tonight. Daniel Gygax, good to see you, Daniel. Thanks for being here from the very beginning. I appreciate it. SMU was the scapegoat for the whole Southwest Conference. The whole conference was paying players. Anybody who could pay was paying. It wasn't just Southwest Conference. Everybody was paying back then. And it was just whether you got caught or not. So, yeah, I don't know. Let's see. I get to a few more comments. I've pretty much covered. See if there's any other. I don't think there's any other stories or threads that I haven't covered. I want to thank everybody for being here tonight. I think I might have missed one comment. Nope, that was Moen giving 5 new members. No, I think that's going to be it, guys. So one last time, I appreciate everybody who's watching. Make sure you subscribe, like the channel, or like the video. Make sure you subscribe to the channel. Follow me on Twitter. Follow Sam and Philip on Twitter. And if you missed the beginning of the show, I would recommend you go back, and they were here for over an hour. Lawyers answering your roster limits, house settlement questions, and it's worth your time. So feel free to clip that up, cut it, and send it out on Twitter, share it with other people. Lots of good information there that you're not getting from most other people, frankly. These guys don't normally do a lot of interviews. I've been lucky and grateful that they've come on our show and done them. But I really appreciate you guys, everything you do for us at the College Football Mafia Network. Thank you for the support you provided me and my team. Your support last week when I was sick really made me feel good. I appreciate it. It was lousy. And if you have family or friends that are currently sick, coughing, avoid them like the plague, because whatever's going around right now can quickly devolve into pneumonia. And my mother caught it, and it was really kind of scary for a little while. So I would just recommend, especially older people, whatever this new virus is going around right now is, protect your families. Wash your hands. Maybe go back to masks just to keep everybody else from what you're doing. But I appreciate you guys so much. Trent Brown, my brother's namesake, checking in. Good to see you, Trent. Always appreciate you being in the comments. Great show as always. Thank you. Everybody have a great night. Stay out of trouble. I want to bump tomorrow. Tomorrow night I might do an ad hoc show. I haven't decided. I'm not going to promise anything, but I might. But certainly we have our members only show. Miami, the ACC realignment, and anything else they want to talk about. Rock and Rant, I believe Wild Ute and Moen are going to be running that show at 8 Eastern time. I want to encourage everybody to tune in. It's a members only video. If you're not a member, become a member. You can catch this and other member videos in our video gallery. And we're well over 100 videos now. And if you want, ask all the people in chat right now live, the new members, especially recent members, if they've gotten their money's worth. I haven't had one person tell me they're not, and I know we are providing value for that. So continue to share your comments and questions with us. Get on Twitter. If you have a story idea, something you want us to cover, send me a DM, and we'll talk about it. My DMs are always open. And I appreciate everybody being here tonight. So I'm going to say thank you again for Sam and Philip for joining me tonight. Catch them on Twitter. And let's get this thing going. Roster limits and the house settlement tomorrow is showdown number 12 at this point, and we'll see what happens with Judge Wilkins. Is she going to slap around the NCAA and the A4, or is she finally going to say, you know what, I want to go golfing, I want to put this to bed? I don't think that's going to happen. I do believe she's going to send it back again and saying, you guys just aren't doing enough to protect these athletes. So thank you so much. Everybody have a great night. And I want you to stay out of trouble. And I don't have this queued up, so give me 1 second here. Let me get this queued up. All right. And with that, we will have a great night. Everybody stay out of trouble, and we will see you soon.